Okay, we are now live and on the record for Monday morning civil docket for March 7, 2022. All right, Mr. McInnes, what do you have?
We've had docket number 37.
Okay, that's CL 21-1711-I, Gem Enterprises versus WBL SPE the third LLC. Announcements?
Yes, Your Honor. This is one that we had announced the last time in February that we had set a mediation for April 1st with Alfred Denham, and that mediation is still ongoing, we've already had one session, and we're going to hopefully finish it up on April the 1st at that next scheduled mediation.
Okay, is anyone here from the defendant?
James Cuellar represents the defendant, Your Honor. I texted him this morning and sent him a copy of the Zoom information because we didn't get it till this morning.
Okay, let's come back on April the 11th at 9:30.
Judge, thank you. I have one other matter, Judge. There is no docket number on it today because last week on February 28th, we were set for a final hearing on a divorce which required a translator uncontested. And y'all told us to come back today because y'all's translator had an unexpected emergency. And that is case number F0207-21-J in the matter of, I'm sorry, I got the wrong number, F-4260-21-9 in the matter of the marriage of Karen Paz Menjivar and Angel Braulio Barrios.
Okay.
Yeah. And I don't know if the court just gave us another setting. My client was going to log in this morning, but I do not see Karen Paz on.
Okay, well, you can come back on the same date. The soonest I have is April the 11th. If you need it sooner, do you want to speak to your client about possibly her availability?
Well, Judge, let's go ahead and set it for April the 11th. And if there's some issue that she requires more prompt hearing, I'll contact the court staff.
Okay, then that'll be April 11th at 9:30.
All right. May I be excused, Your Honor?
Yes, sir.
Thank you.
Thank you. Okay, Mr. Velasquez?
Morning, Your Honor. I have quite a bit of default prove-ups I just wanted to let you know about. I'm not quite sure how you want to take that up with the docket, but there are
Okay, so
29.
you're doing the motions for default judgment this morning?
Yes, Judge. We're just seeking judgment in those cases, and I don't know if we want to take them up individually or.
Okay, yes, we do take them up individually. What I'll do is I'll take everyone up and then just check back in. If you want to check back in about 20 minutes and see how far we are on the docket.
Okay, Judge. I have also some business in County Court at Law Number 5. May I be excused to attend to that, and then I can check back in with the court?
Okay, that's fine.
Okay, thank you, Your Honor.
You're welcome.
All right.
Okay, Mr. Garza?
Good morning, Your Honor. We're here on number 35 on your docket.
Okay, CL 22-0274-I, Gilberto Galindo Martinez versus Rolando Piñon Robles.
Good morning, Your Honor. Bill Garza on behalf of Defendant Robles.
Justin Davis, Your Honor, on behalf of Gilberto Martinez.
Good morning, Judge. Ricardo Villanova here for a defendant that's in the other court. That's under ASI.
Correct, Your Honor. What I have filed is a motion to consolidate this case with a pending lawsuit in County Court at Law Number 5. It involves the exact same accident, same set of facts as the one filed in your court, Your Honor. So we're asking the court to consolidate the one in your court and transfer it and consolidate it with the case pending in County Court at Law Number 5 bearing CL 212374E.
And Your Honor, Justin Davis again for the plaintiff in this case, and we don't have any objection to the consolidation.
Okay, Mr. Villanueva, do you have an objection?
No objection, Your Honor.
Okay, Then your motion to consolidate is granted. Do you have an order on file?
I think there is one, but I'll double check, Your Honor, and if not, I will get one on file this morning so the court can sign it and we can proceed in the other court.
Okay, sounds good.
That's all
Anything
I
else,
have.
gentlemen?
That's it.
It would
Thank
be
you, Judge.
excused.
Okay, thank you. Y'all have a good day.
Thank you,
Thank
Judge.
you.
Have a good day.
All right, thank you. Okay, Ms. Hopkins?
Good morning, Your Honor. How are you?
Good morning, ma'am.
If I had raised my hand, I didn't mean to.
No, that's okay. It said I don't
Okay.
have any more people that raise their hands, so we'll take you in the order that I see you all. So
Okay.
you have a motion for summary judgment?
We do, Judge, this, just a reminder, this has been reset a few times. I do believe Mr. Rayfield's on, and he is urging another motion of continue. If we take up that motion to continue and it's not granted, then we probably need, maybe 30 or 45 minutes on our motion.
Okay, Mr.
Maximum.
Rayfield, this is on CL 186390-I, Angelita Brunella et al. Versus Gregory Funding et al. Go ahead, Mr. Rayfield.
Good morning, Your Honor. I'm attorney for the plaintiffs, co-counsel, along with Leo Pruneda, who is one of the plaintiffs, Your Honor. Did file we do have a summary judgment here being on hearing today. I did timely file a response to the summary judgment. Unfortunately, I filed it to the wrong summary judgment. To make a quick argument, I filed the motion to continue this after realizing I filed the wrong one. What happened was, Your Honor, the defendants had prior attorneys in this case, and Nathan Milron, he filed a summary judgment on May 6, 2020. He got out of the case. Ms. Hopkins got in the case. She filed a new summary judgment after she came into the case. She filed a new one. Hers was filed. I filed a response to the first summary judgment. Mr. Millens, not Ms. Hopkins. I filed a response on February 28, 2022, which would have been timely for today, Judge. This is the typical case of not conscious indifference. I got a hold of the wrong summary judgment. I filed a lengthy summary judgment response. I objected to the evidence. Opposing counsel thinks it's not valid, but that's her job. She's proposing, she's supporting a motion for summary judgment. It was not conscious indifference, Judge, because I did file a response. I did file a timely response. It was just to an earlier version of the summary judgment. So I'm asking the court for more time to assist Mr. Pruneda in that, Your Honor. He is currently down at the courthouse as well. He's in the 370th court. He wanted to be here, but some courts are doing live hearings and some are doing Zoom. So there you have it.
Okay, Ms. Hopkins?
Judge, just given the time that our motion's been on file, I request the court deny the motion to continue. And I did advise counsel on the day he filed the response that it was a response to the wrong motion and that I would allow him additional time to file a response to the correct motion, but I didn't hear back from him. I don't know if he didn't receive my email timely or what. I also advised, I do want to get this heard. I am not opposed to continuing it if we can get a very quick date so that we can have this fully briefed and not have any issues with reversible error if it's granted and we go up. So I'm opposed to the continuance in theory, but not if we can get a quick setting.
And if I may, just to finalize, Judge, I think I've shown good cause. This clearly is not conscious indifference, and I believe the court has the power when there is a showing of good cause. In addition, there's no undue prejudice. There's some money in the registry of the court. Mr. Pruneda is living in the house and maintaining it well. This is a foreclosure action where they're trying to foreclose on Mr. and Mrs. Pruneda. So our argument would be that we would appreciate the continuance, Your Honor, so that we can do it of whatever length the court would consider. That's up to the court. This new summary judgment is different than the one I've drafted the response to. It's a final summary judgment and not an interlocutory one. So I would like a little bit of time to consider that. She did send me an email about the wrong summary judgment, Your Honor. I'm sorry, I had court hearings and other things of that nature. And whereas I was able to get a response in 7 days before, I couldn't then amend it thereafter, Your Honor. Thank you. And we did file a verified summary judgment motion verifying this information that regarding the request for the extension, Your Honor.
Okay. Let me see. The soonest that I can do is March 23rd at 11.
That works for my schedule, Your Honor.
I don't have any settings at that time.
Okay, then we'll see you back then. I suggest you get that in as soon as possible, Mr. Rayfield.
I will, Your Honor. Thank you very much for your consideration.
Okay, thank you.
Thank you, Your Honor. May we be excused?
Yes,
Thank you, Your Honor.
yes. Okay, I think Mr. Ruiz, yours is a contested motion, is that correct?
Good morning, Your Honor. Yes, that is correct. It's a motion for summary judgment filed by opposing counsel, Mr. Simon.
Okay, does anyone else have a quick announcement before I take up that summary judgment? Let me see, Mr. Garcia, what do you have? I believe you're on mute, Mr. Garcia.
Ma'am, I'm sorry, CL 164509I, number 36 on your docket. Flores versus Garcia. Mr. Aaron Vela is on the line here.
Okay,
We have a status conference hearing.
all right, Humberto Flores versus A. Garcia Produce and Trucking et al. And what is the announcement, gentlemen?
We're still working, Your Honor. We're trying to get something done as far as getting to a mediation and stuff. But we still got a little bit more work to do. This case I know is old, but it was at the Court of Appeals for like 2.5 years. And before that, we had filed it late in the year. So saying it's 16 is a little bit, not that it's inaccurate, but it's not quite the whole year. So that's why this case has gone on as long as it has. We were at the Court of Appeals for literally 2.5 years.
Okay, Mr. Vela, anything to add?
No, Your Honor. I think
Okay.
we're just here for status.
Okay, so now that you're up and going with this case, so do you have how's your discovery process, or are y'all ready to mediate this?
We're still in discovery, Your Honor. Mr. Garcia took the deposition of the defendant, and we still need to take deposition of the plaintiff and conduct some more written discovery. I had requested information for tax returns and other information that Mr. Garcia was working on. Some of that was unavailable to him that we will either work out or try to get from the IRS. After that, Your Honor, it'd be wrapping up some written discovery and taking another deposition or two, and then trying to work out something at mediation.
Okay, then let's come back on June 1st at 9:30. And then let's see how you all are by then.
Okay.
Okay, anything else?
No, Your Honor, thank you. That's all I have. May I be excused?
Yes, you certainly may.
May I be excused, Your Honor?
Yes, sir.
Thank you. Thank you.
Thank you. Okay, Mr. Trevino?
Good morning, Your Honor. Gregorio Treviño for Esmeralda Gonzalez, respondent.
Okay, what number, sir?
Judge, it's 3670, F3670. I have no number on the docket. I apologize, Judge. F3670, 21.
Okay, that's number 32 on the court's docket. In the matter of the marriage of Rolando Gonzalez and Esmeralda Gonzalez.
Yes, Your Honor.
Okay, what is the announcement?
I filed an answer for Ms. Gonzalez. She's not legally trained. She had not filed an answer. She retained me. I filed an answer on the 22nd, Your Honor. And I'm hoping that I can work this out with Mr. Maldonado.
Okay, and how much time do you need, sir?
Judge, to get some correspondence going, maybe perhaps a meeting or two, perhaps 30 days, Your Honor.
Okay. We can come back on April the 11th.
Very well, Your Honor.
and I'll at 9:30, and I'll go ahead and set it for a status.
Very well, Your Honor.
Okay?
Thank you, Judge. And I'll let Mr. Maldonado know, and we will talk about this.
Okay, sounds good. Thank you.
Have a safe day, Judge.
Go ahead.
Judge, for the record, Ms. Gonzalez is present in the courtroom. I'm going to be excusing her.
That's correct. She's present.
Okay, yes, go ahead and she can be excused. Thank you.
Thank you,
Okay,
Judge.
Ms. Hernandez, what case do you have?
Good morning, Your Honor. Luis Hernandez here on number 16, Your Honor. This is a default judgment. I represent the defendant, Lisa Luna.
Okay, CL 193375-I, Portfolio Recovery Associates versus Brisa Luna. Brisa Luna?
Yes, Your Honor. She is not present. I'm not sure. I haven't seen the attorney for the plaintiff. I filed an answer on Thursday and a motion for continuance, Your Honor.
That would be me, Judge. I'm sorry.
Okay, yes, that
Okay.
would be,
Okay.
yes, that would be Mr. Velasquez, okay?
Okay. Yes, I just need maybe 30, 45 days, Your Honor. I'll probably, I'll contact Mr. Velasquez and try to reach an agreement, Your Honor. I don't think it's going to take that long, so I just need a short reset if the honor would, Your Honor would allow that.
Okay, you will come back on April the 11th at 9:30.
For status, Judge?
Yes.
Okay.
If y'all have it worked out before then and you submit your paperwork in time, then you won't have to come in that day.
Okay, perfect. Thank you, Your Honor. May I be excused?
Yes,
Thank you.
okay?
And Judge, I was just hanging out because I have a hearing at 10 in County Court at Law 5, so I was on mute, but I'm in the
Okay.
background.
No, don't problem. All right. Mr. Simon, Attorney Paul Simon?
Yes, Your Honor. I'm here on the same matter as Mr. Ruiz for the motion for summary judgment.
Okay, let me see, Mr. Ortegon, do you have a quick announcement?
Your Honor, I have a proof, both of the clients are logged on, Judge. It's just an uncontested, simple divorce proof up, Your Honor.
Okay, what number is that?
Let me get that for this.
Oh,
honorable
number
court.
31. That's F5099-21-9 in the matter of the marriage of Luke Christopher Kruger and Aurora Denise Kruger.
That is correct, Judge. And they're both present, Your Honor. They both have signed the decree. And we're present and ready for proof up, Judge. It's no children, no property, not that.
Okay, Mr. and Mrs. Kruger, can I please have you both unmute yourselves?
Do you hear me?
Yes, okay, can I please have both of you raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Mr. Kruger, yes or no?
Yes, Your Honor.
And Ms. Kruger, yes or no?
Yes.
Okay, you may lower your hands. Mr. Ortegon, you may proceed.
Yes, Luke, will you please state your full name for the record?
Yes, my full name is Luke Christopher Kruger.
Okay, you're the petitioner in this case, is that correct?
Yes, sir.
Okay, now prior to filing for divorce, had you lived in the state of Texas for the preceding 6-month period?
Yes, sir.
Hidalgo County
Yes,
for the
sir.
birthday period.
Yes.
Okay, now you filed a divorce against Miss Aurora Kruger, is that correct?
Yes, that is correct.
And your allegation is that it's irreconcilable differences, basically no fault divorce, is that correct?
Yes, sir. That is correct.
Did you guys have any children?
No, sir.
Did you guys obtain any community property?
No.
So you're asking that this honorable court grant you whatever's in your possession and Miss Aurora whatever is in her possession. Is that correct?
That is correct.
Okay. Now, as far as you're concerned, is Kruger this time?
I'm sorry, you broke up, Mr. Ortegon.
As far as you're concerned, Luke, is Kruger pregnant at this time?
Oh, Aurora Kruger? No, she is not, as far as I'm concerned.
Okay. Now, are you asking that this honorable court approve your divorce?
Yes, that is correct.
Judge, I pass the witness.
Okay, do you have any questions of Ms. Kruger?
I have like two questions of Ms. Kruger, Your Honor.
Okay, go ahead.
Ms. Kruger, will you please state your full name for the record?
My current one or the one that I'm changing to?
Your current one.
Aurora Denise Kruger.
Okay, and you read all the questions that I asked Luke, is that correct?
Yes.
Are you currently pregnant?
No.
Okay, and did you and Luke have any children?
No.
You're also in agreement that there was no community property and that whatever's in your possession will remain with you and whatever's in Mr. Kruger's possession will remain with him. Is that correct?
Correct.
Okay, and are you asking that this honorable court grant your divorce?
Yes.
Okay, and though I did not represent you, have I been courteous to you throughout this entire process?
Yes.
Okay. And requesting a name change, is that correct?
Yes.
Okay, and that is to what?
Aurora Denise Hernandez.
And that is your maiden name, is that correct?
Correct.
And I know Mr. Kruger already signed the decree. You're coming into my office this afternoon to sign this, is that correct?
Correct.
Nevertheless, that name change is in the final divorce decree.
I'm sorry?
Correct. And nevertheless, the requested name change is in the final divorce decree. Is that correct?
Yes, correct.
And are you also asking that this honorable court approve your divorce?
Yes, correct.
That's all we have, Your Honor. The decree has been drafted. Ms. Kruger, soon to be Ms. Hernandez, coming into my office this afternoon to sign the decree, Judge. We will be filing that with the court before the end of the business day. We would respectfully request that this divorce be granted, Judge. A waiver is on file.
What is the date of marriage?
The date of marriage, Your Honor, is December 28th, 2015. Date of separation, July 25th, 2021.
Okay.
I apologize for not mentioning that. I haven't had an uncontested divorce in years. It's nice.
Okay, the court is going to grant the divorce and the relief as requested on the record. And Ms. Kruger's name is changed to Aurora Denise Hernandez. And just have that divorce decree on file. And I'm going to set a tickler for March the 25th to make sure that it's submitted by then.
Thank you so much, Your Honor. It'll be filed before the end of the business day. That's all we have, Judge. May we be excused?
Yes, you both may be excused.
Thank you so much, Your Honor.
Okay, thank you. All right, Mr. Ibarra, Christopher Ibarra.
Yes, good morning, Your Honor.
Good morning, sir. Are you here on the Delaney Ibarra?
Yes, the Calashay Delana.
Okay, and who is your attorney, sir?
It's Melissa Canales.
Okay, can you please contact her and let her know that you are next?
Okay.
Thank you.
You're welcome. Thank you.
Okay, let me go ahead and take up Mr. Ruiz and Mr. Simon because the rest are motions for default judgment and there's a lot of them. So I'll go ahead and have you make your announcements on CL 195846-I Sandra Guerra versus Discovery Clinical Trials et al.
Good morning, Your Honor. Mauro Ruiz for Ms. Guerra.
Good morning, Your Honor. Paul Simon for the defendants.
Okay, and go ahead.
Your Honor, this is defendant's motion for summary judgment. This is a pretty straightforward employment discrimination case. Plaintiff is claiming that she was terminated based on national origin and age. She's a Mexican-American female over the age of 40. Your Honor, defendants contend that plaintiff is not able to establish her prima facie case under the McDonnell-Douglas burden shifting analysis. And the fourth element of that prima facie case is that the plaintiff must establish that she was either replaced by someone outside of her protected class or that a similarly situated employee was treated more favorably than her, Your Honor. We believe the evidence shows that the similarly situated employee that Ms. Guerra is trying to utilize is not a similarly situated employee. The Texas Supreme Court is pretty clear on this, that for a similarly situated employee, it must be similar circumstances under basically all comparable material respects, including similar standards and conduct. and supervisor. And in this case, Your Honor, the evidence, and plaintiff does not dispute this evidence, that the similarly situated employee that plaintiff is trying to rely on was supervised by a different employee up in Dallas. Ms. Guerrera was employed down in Hidalgo County. And so for that reason, it's not a similarly situated employee. And then taking that a step further, the conduct is completely different. Ms. Guerrera was terminated based on being unprofessional to her supervisor, and she had a prior discipline on her record. The person that plaintiff is relying on is similarly situated. Basically, what plaintiff's contending is that this employee was at a company dinner function and, in plaintiff's opinion, got drunk and was dancing and she didn't think was being appropriate. Defendant has testified that they did not view what that employee was doing as anything that violated any sort of company policy. And so again, completely different conduct. And for that reason, Your Honor, we would ask for summary judgment be granted because she's not able to establish her prima facie case. If this court believes that she is able to establish her prima facie case, then the burden would shift to defendant to offer a legitimate non-discriminatory reason, Your Honor, and we have done that with the evidence that she was terminated based on a letter from her supervisor that plaintiff was disrespectful, basically not following directives, and for that reason, defendants terminated the employee, which then would shift the burden back to the plaintiff to establish pretext. Plaintiff has not provided any evidence of pretext. Instead, basically what plaintiff has done is object to defendant's evidence as to their legitimate non-discriminatory reason, Your Honor. And we've outlined that in our reply, but essentially plaintiff is arguing that it's hearsay because it's the CEO of the company who has submitted an affidavit. Your Honor, we believe that that affidavit establishes that it's a business record, basically relying upon the termination notice that's a company record, along with the attachments that were included in that company record. As the CEO, she has knowledge to identify the process in which the business maintains its records. And so we believe that her affidavit sufficiently establishes that. But again, that's just if we're dealing with the next element, but we believe that the prima facie is strong enough, Your Honor, for you to grant a summary judgment.
Okay, Mr. Ruiz, your response?
Okay, Your Honor, thank you. So the prima facie case is the way to look at it. Can the plaintiff get his or her foot in the door to establish a discrimination case under Chapter 21 of the Texas Labor Code? Mr. Simon is challenging the fourth element of that prima facie case. He's not denying that Ms. Guerra is Hispanic, that she's a female, that she's over 40. He's also not denying that a Caucasian Anglo was treated better. He's saying they're not similarly situated. Well, the CEO's sham affidavit that is attached in support of summary judgment says that Ms. Prince, the Caucasian who we believe was treated better, was also a clinical researcher like Ms. Guerra. That's in Ms. Maiden's affidavit. And so in her deposition, it was in Trudy Maiden's deposition, she confirmed that if someone acts unprofessionally at one of the conferences that they have for the statewide employees, she said that Ms. Prince should have been terminated if she acted unprofessionally at a conference. And that was Ms. Maiden's deposition testimony on pages 55 and 56. Ms. Maiden, the white, similarly situated Caucasian female, never got disciplined. So there is a fact issue as to the fourth element of plaintiff's prima facie case. A younger white female was treated better than plaintiff and was not terminated for unprofessional conduct, which is the same conduct that they claim Ms. Guerra was terminated for. Your Honor, I did raise some objections, but I know the court's always on short you've got a lot of default judgments, Your Honor. It's preserved in the motion if the court would like to consider it. There is also a fact issue because the plaintiff was replaced by a younger female. Again, in the sham affidavit that they mentioned this, Trudy Maiden, the CEO, says that Yunko Castro, who is under 40, replaced the plaintiff. So I don't know why they're attacking those elements of the prima facie cause of action. There's also a third fact issue. There's also a fact issue because there were illegitimate pretextual reasons for plaintiff's termination. Now, what's interesting here is that the CEO drafts an affidavit, but yet in her testimony, she admits that she was, quote, peripherally involved and was not day-to-day when Ms. Guerra and Ms. Muro, a co-worker, and Ms. Muro also has a case in your court, Your Honor, were terminated. So the person with actual knowledge is no longer employed, and they never provided an affidavit from that person. And so we know that from the Fifth Circuit, Your Honor, the Fifth Circuit held the jury could find alleged misrepresentation was a pretext because neither decision maker had read the questionnaires or made any effort to investigate whether the medical assumptions were incorrect, even though the plaintiff had given them info that did not support that assumption. The Fifth Circuit goes on and says a jury reasonably could find that the employer first decided to fire the plaintiff because of her disability or accommodation request, and only afterwards developed the purely pretextual reasons they advanced for their actions. Now, that's exactly what we have here, Your Honor, except it is for age and national origin. Clearly, they treated white Caucasian females better who did not behave according to standards, getting drunk, hitting on men at a conference. Trudy Maiden, the CEO of defendant, said that's unprofessional, she should have been terminated. And then they have a younger female under 40 replace Ms. Guerra as a clinical researcher. I think it's interesting that Mr. Simon wants to dispose of this case, Ms. Guerra, on National Women's Month. I don't know if it's an added plus for him or what, but there are 3 fact issues that the court should identify and deny the motion for summary judgment. Thank you, Your Honor. That's all we have.
Okay. Anything to reply, Mr. Simon?
Your Honor, just a couple quick notes. If you look at the affidavit provided by Ms. Madden, it specifically says, and as Mr. Ruiz pointed out, he's got 2 lawsuits against my client. And my client has replaced an employee related to his other plaintiff, Ms. Murrow, but the affidavit specifically says that plaintiff or defendants did not replace anyone for Ms. Guerra, and they've provided 0 evidence to contradict that, Your Honor. So that's just a misrepresentation of what the affidavit says. And again, defendants disagree that they believe that Ms. Prince acted unprofessionally and therefore that she was somehow treated better. Again, if you look at the affidavit, Ms. Madden says she was at this event. She did not view this, what Ms. Prince was doing, as any sort of violation. Mr. Ruiz is doing his best to try to say that that's similar conduct. Again, what you do at a company dinner is completely different than whether or not you're following directions of your supervisor. So we don't believe that. And again, the Supreme Court is very clear that because they have different supervisors and therefore different decision makers are making the decision as to how to discipline them, it's not a similarly situated employee that she can rely upon. So for those reasons, we believe that defendants are entitled to summary judgment. We filed this back in October. The month of March should not impact this court's decision.
Okay. All right, then I'll go ahead. I'm going to take this under advisement and then I'll go ahead and issue a ruling. Do you all have your competing orders on file?
I believe so, Your Honor.
Yes, Your Honor.
All right. All right, and then that's what I'll do, gentlemen. I'll go ahead and let's set this up. Other than that, let's just say that you survive how are we doing with respect to discovery and all of that? Have y'all continued to proceed with that?
Well, Your Honor, the discovery has been conducted with respect to the deposition of the CEO. One of the ladies, I don't remember her name. I think the lady who was involved in the termination is no longer employed, and I don't know if she's within the jurisdiction of this court in order to subpoena her. There's been some limited discovery done, and I think maybe a depo or two more would be needed. I don't see defendants willing to mediate. That's why I had previously asked on the other case if we could just go to trial on it, but the court made it abundantly clear that every case has to get mediated.
Your Honor, and I don't believe we've conducted any sort of discovery for at least 6 or 7 months. I mean, defendants are ready to go to trial. I'm happy if Mr. Rees wants to request a deposition. If, and again, I believe the people he wanted to pose are no longer with us, but we can at least attempt to try to arrange those. But yeah, I think any further delay on this case out of the guise of further discovery, I just have concerns with. Defendants have never said they're unwilling to mediate. Mr. Ruiz and I have had informal discussions, and I've given him the value that I believe this case is worth, and him and I just simply disagree on that. But we are always open to mediation.
Well, Your Honor, when they send you an offer for $500, which barely covers the filing fees and depositions, it doesn't seem like it's a serious offer. And so what happens, Your Honor, because in employment law cases, usually defendants don't get serious until motions for summary judgment get denied. These are the first cases I have with Mr. Simon. Until motions for summary judgment by the defendant are denied, they really don't consider anything serious about mediation, and you get ridiculous offers out of the blue, which I didn't even request this $500 offer. And so they don't get serious until that happens. So, Your Honor, I think the evidence is enough for the court to actually deny both motions for summary judgment. And then maybe perhaps they take the cases a little bit more seriously, considering the economic cost and factors of going to trial. But that's what usually happens in my employment docket. I have 60% of my docket is employment discrimination cases, and that's what usually happens. State or federal court, it's the same thing, Your Honor.
Okay, let's go ahead and come back for a status hearing on April the 27th, if necessary.
22nd or 27th, Your Honor?
27th. And that'll be at 9:30.
Thank you, Your Honor.
Thank you, Your Honor. May we be excused?
Yes.
Thank you. Have a good day.
Thank you. All right, Mr. Maldonado, can you hear me? Mr. Maldonado's office, can you hear me?
I can, Your Honor.
Okay, so Mr.
Good morning.
Trevino made an announcement on your case, and you're set for a status hearing on April 11th at 9:30.
Okay, Judge, that's all I have. Thank you for calling the case.
Okay, you're welcome.
Good day.
Okay, Mr. Ibarra, were you able to contact your attorney?
Yes, ma'am. She said that she is logging on right now.
Okay. Well, we'll see if she gets on, we'll go ahead and take her up. All right, Mr. Velasquez, are you in your hearing or are you out?
Judge, he sent me a message that he was stepping into County Court 5.
Okay. Go ahead and send him a message to let us know when he's back. His cases are the only ones that are left. Okay, we'll go ahead and take a brief recess. We're now off the record.
Yeah.
Okay, Ms. Canales, can you hear me?
Yes, Your Honor, I can hear you. I'm sorry, I'm just trying to find a place. I have a makeshift office in the vehicle, Judge.
Okay. All right, Ms. Flores, are you ready?
Yes, Judge.
Okay, so we're back on the record for, let me go ahead and call your case. And that is F450-07-9 in the interest of a minor child. Mr. Ibarra is present. Was there anyone else that was supposed to be present?
Your Honor, the mother, who is the respondent, she had appeared on this case. She was served and she had appeared on this case, Your Honor, back in 2019 in October in Judge Palacios' court. So she was properly served, Judge. I have tried to send her notice. I sent her 2 notices and at her last known address, and those have been since been returned.
Okay, so is there another way of letting her know of today's hearing or of a future hearing?
Well, Your Honor, my client has not had contact with her. This is a very unfortunate case, Your Honor. She was an avid drug user, and there was a lot of harm caused to the child. The child is now a sophomore in high school, so they haven't had contact with her in quite a while, a couple of years. The family did learn through a relative that she has since had another child, but that child is in foster care because of her drug use. So I think maybe we don't know where she physically lives, Your Honor, but they do have contact with extended family.
Okay, and what is it that what relief are you asking for? Because I'm locked out of my Odyssey. I don't know what they're doing to it.
Your Honor, we're asking for sole managing conservatorship. And that's in our pleadings. Judge Palacios did give us temporary sole managing 2.5 years ago, Your Honor, because the mother does have suffers from many diagnoses. She has a few episodes in the courtroom also. She's schizophrenic. And we got this off of medical records, Judge. She has homicidal ideations. She has psychosis. She's bipolar. She's a severe manic depressive. So that's why we're asking for sole managing conservatorship, Your Honor.
Okay, so is the child with your client or still with the mother?
No. The child is with my client, Your Honor. She's already been with my client full time for 2.5 years.
Oh, okay. So you're just asking to make the temporary orders that Judge Palacios had implemented into final?
Yes, Your Honor.
Okay. And he never ordered an ad litem or anything like that then?
No, Judge.
Okay. And so she's never filed for a modification to try to see about getting the child back?
No, Your Honor.
Okay. So you're saying that it's in the best interest of the child for those orders to be made permanent?
Yes, Your Honor. And I would like to offer the affidavit as an exhibit, which is the affidavit from the custodial parent, the father, of the reasons why he wants sole managing, Your Honor.
Okay, well, since he's available for testimony, he can testify as to those points in the affidavit. So, Mr. Ibarra, can you raise your right hand?
Yes, ma'am.
Did you want to turn on your camera, or you have a reason for turning it off?
Is it? No, I just, let me get my daughter to help me. I thought I was on already. Kelly.
Okay,
Oh, come. I'm sorry, Your Honor.
it's fine. There you go. Okay, sir, raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you may lower your hand. You may proceed, Ms. Canales.
Can you please state your full name for the record?
Christopher Daniel Ibarra.
And what is the name of your daughter?
Kalishay Delana Ibarra.
Her date of birth?
It is 6/29/06.
And how old is she right now? And what grade is she in school?
She is 15 and she's a sophomore in Mercedes High School.
Okay. And when is the last time that your daughter visited with her mother?
The last time she visited with her, maybe I would say about over 2.5 years, 3 years.
Has her mother reached out to try to contact her, or to your knowledge, has she filed anything with the court?
No, ma'am.
Okay. And back in September of 2019, you wrote an affidavit stating the reasons why you wanted the court to grant you sole managing conservator. Can you state some of the reasons why you're wanting this to be finalized with the court today?
Yes, ma'am. She has had several diagnoses from tropical, and she is acute schizophrenia, like you mentioned, attention deficit disorder, homicidal ideations, illicit drug use, increased insomnia level, severe manic bipolar disorder, and psychotic features. And there's been a lot of times as well when she did have custody of her and she lied. She previously worked for Child Protective Services, and she has lied multiple times at my daughter's old schools that she would go to, and she would lie, I guess imposing still as a CPS officer, just to try to go and talk to her, or just be there at the school. I have no idea why, but she would just get in a lot of her episodes. She doesn't take her medication. She would do drugs in front of my daughter. She would have various men over and they'd be doing drugs in front of my daughter, and she herself did not feel safe at all.
Okay. And does she have a stable life right now that you know of? Does she have a stable home?
As far as her mother, right? As far as I know, I do not know. I have not heard anything. Just her mother's the one that told my daughter that she did have another baby, and it also got taken away. It's in foster care right now. But
okay.
I do not know where she lives. I do not know I know she would sleep at a shelter before, at a homeless shelter, but I haven't heard of her in years, so I don't have contact.
When she did have possession of your daughter, where was she living at that time with your daughter?
She had lived with her mom for a little while, and then they went and stayed at I think it's the Fish and Loaves or something, the homeless shelter in Harlingen. And as far as that, she was just bouncing around from friends and wherever. She didn't have no stable household or anything.
And what do you know what types of drugs she was abusing?
I know she would smoke marijuana, and then I believe cocaine, and she also would do Xanax bars and all kinds of, I guess, pills or whatever.
Okay. And as far as it being a danger to your daughter, did she ever put your daughter in a dangerous predicament? Like, did she drive with her in the car?
Yes, ma'am. There was various times that my daughter did say that she drove and she was speeding, driving crazy, and she was highly intoxicated.
Okay. And your daughter is a sophomore in high school, correct?
Yes, ma'am.
Okay. And you're asking the court today to grant you sole managing conservator. And at this time, you're also asking the court not to allow visits until her mother brings you a clean drug test, correct?
Correct.
Okay. That's all I have, Your Honor.
Okay. In light of what has been put on the on the record, then the court feels that it is in the best interest of the child to go ahead and make the temporary orders that were issued by the previous court into final orders. And the court will grant the relief as requested on the record by Mr. Ibarra. Do you have an order on file, Ms. Canales?
I don't, Your Honor, but I do have one other matter. I want to go ahead and ask for child support, Judge, at the minimum wage. And I don't have the amount right now, Judge, but I do want to go ahead and ask for back child support from the time that we filed this. I think we left that for final when we did the temporary order, Judge. And it would just be at minimum wage, Your Honor.
Okay, well, is that on your pleadings?
Yes, it is, Judge.
Okay, so there hasn't, had you brought up that issue in the temporary orders?
Let me check real quick, Judge. I did ask for her to pay child support in the temporary orders. Yes, Judge.
Okay, and Mr. Ibarra, you're still asking for her to pay child support to you?
Yes, ma'am.
Okay. Well, you'll need to put on some testimony for him as to the retroactive amount. What are the amounts? Is this child on Medicaid?
Yes, she is.
She is on Medicaid. Yes, Judge.
Okay, and has the Office of the Attorney General, are they going to be filing an intervention to your knowledge?
Your Honor, we do have an open case with them. They do have an open case, Your Honor. If the court would like, we can go ahead and, I don't know that we notified them of this hearing, Judge. We can go ahead and suspend the hearing as to the child support amount so I can bring them in, Judge.
Okay, let's go ahead and just notify the AG's office. The only issue that we'll leave pending is the child support, and we'll have them come back on, the earliest I have is April the 11th.
Very well, Your Honor. I'll let them know.
Okay. All right. Okay, then we'll excuse you, Mr. Ibarra, until April 11th at 9:30.
Okay, thank you, Your Honor.
Okay, thank you.
Bye-bye.
Okay, bye. Okay, Mr. Velasquez, can you hear me? Okay, I'm guessing he's still in the other court. All right, we'll take a quick 5-minute break and then we'll return to see if he's ready.
I'm back, Your Honor.
Okay. Let me see, is my, Ms. Flores, are you ready?
Yes, Judge, ready.
Okay, so go ahead, Mr. Velasquez, we're back on the record.
Thank you, Judge. Your Honor, I have number 1 on your docket sheet.
All right, CL 15-2934-I, Midland Funding versus Guadalupe Delgadillo, okay? No response, go ahead.
Your Honor, I would ask the court to take judicial notice of any and all documents previously filed with the court. We are seeking damages in the amount of $2,155.50. Cost of court and post-judgment interest at statutory rate. I would move the court at this time to admit any and all exhibits without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that it was served properly. No answer is on file. The required amount of time has passed. And the court is granting the relief as requested by the plaintiff and set forth in an order that have you already filed that order with the court?
I believe we have, Your Honor. And if
Okay.
we have not, then I'll make sure that gets filed.
Okay, your next case?
Number 2 on your docket.
CL 154257-I, Jefferson Capital Systems versus Sylvia Rios. Okay, you may proceed.
At this time, Judge, we are moving for a default in the amount of $596.14, cost of court, post-judgment interest at the statutory rate. I would move this court at this time to take judicial notice of any and all pleadings and citation that have been previously filed with the court and admit any and all documents and exhibits filed with the court in support of this morning's proof.
Okay, the court is granting the relief as requested on the record, specifically that an answer has not been filed by the defendant. The required amount of time has passed. The court is granting the relief as requested on the record by the plaintiff and set forth in an order that has been filed. So we'll ask for that to be forwarded. Your next case?
Number 3 on your docket sheet, Your Honor.
CL 161080-I, Midland Funding versus Rodolfo Celedon. Go ahead.
Thank you, Judge. At this time, we are moving the court for damages in the amount of $8,294.45. This is a default judgment. Judge, I would move the court at this time to take judicial notice of any and all pleadings, specifically that a defendant has failed to file an answer or any other pleading constituting an answer, and as such, plaintiff is entitled to a default. I would also move the court to admit any and all exhibits previously filed with the court.
Okay, the court is granting the court is taking judicial notice of all the documents in the court's file. The court is granting the relief as requested by the plaintiff and also that there is no answer on file by the defendant. The required amount of time has passed. And therefore we'll sign the order.
Judge, on this one, the order is pending.
Okay, the order to be submitted.
Okay, Judge, thank you.
Okay, next.
The next one is number 4 on your docket sheet.
CL 162605-I, Cascade Capital versus Javier Loya and Ruby Martinez. Javier Loya, Ruby Martinez. You may proceed.
Thank you, Judge. At this time, we're moving the court for a default judgment in the amount of $5,772.60, cost of court, post-judgment interest at the statutory rate. I would move the court at this time to take judicial notice of any and all documents and citations that have been returned to the court. Defendant has failed to file an answer or any other pleading constituting an answer. As such, plaintiff is entitled to a default and for the amount and relief requested.
Okay. The court is taking judicial notice of all the documents in the court's file, specifically that an answer has not been filed.
Judge.
Go ahead.
If I may, I apologize. Judge, on this case, there was no motion for default ever filed, just the order sitting hearing, Your Honor.
Okay, so we can't take up this case. Your motion for default judgment was not filed.
Sorry, I will have the attorney of record in the office file that.
Okay. Your next case?
Your Honor, I have my next case, but I don't believe it's on your docket sheet. That's CL 17-0666-I.
Yes, it's number 5 on the court's docket. Springleaf Financial versus Juan Vera. Juan Vera. You may proceed.
Thank you, Judge. At this time, we are moving for default judgment in the amount of $670.33. This includes credits totaling $1,602.53. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court.
Okay, the court is taking judicial notice of all the documents in the court's file. No answer has been on file, and the required amount of time has passed. And what is the amount that you're looking for?
$670.33, Your Honor.
Okay. And the court is going to grant the relief as requested by the plaintiff.
My next case is number 6 on your docket sheet, Judge.
Okay, give me one moment.
Okay.
Okay. So number 6 at CL 174593-I, Cons Appliance versus Saulo Mora. Go ahead.
Thank you, Judge. At this time, we are seeking a default judgment in the amount of $6,680.11. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits without objection previously filed with the court.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that an answer has not been filed and the time has already passed. The court is granting the relief as requested by the plaintiff on the record. Okay.
Next one is number 7 on your docket sheet, Judge.
CL 174683-I, TD Bank versus Denise Marichalar. Go ahead.
At this time, Judge, we are seeking a default judgment in the amount of $1,496.84. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed. The required amount of time has passed. The court is granting the relief as requested by the plaintiff. Go ahead. And so that'll go ahead to your next case.
Yes, Your Honor. Number 8 on your docket sheet.
Okay. CL 180217-I, Cons Appliance versus Aaron Gonzalez. Go ahead.
Your Honor, this morning we're seeking default in the amount of $5,419.20. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that an answer has not been filed. The required amount of time has passed. Therefore, the court is going to grant the relief as requested by plaintiff on the record. Okay, your next case.
Your Honor, number 9 on your docket sheet.
CL 183967-I, Security Credit Services versus Erlinda, Herlinda Sandoval. Erlinda Sandoval. Okay, go ahead.
Your Honor, we are seeking a default judgment amount of $1,084.20. Cost of court and post-judgment interest at the statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed. The court is granting the relief as requested by the plaintiff on the record. record. Okay, next.
Number 10 on your docket sheet, Judge.
CO 184483-IJH Portfolio Debt Equities versus Yesenia Hernandez. Yesenia Hernandez, Yesenia Hernandez.
Judge,
Go
at this
ahead.
time, we are seeking a default judgment in the amount of $6,259.43, cost of court and post-judgment interest at the statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that a answer has not been filed on behalf of the defendant. The required amount of time has passed. The court is granting the relief as requested on the record by the plaintiff. Okay, your next case.
Number 11, Your Honor.
CL 185196-I Portfolio Recovery Associates versus Martin Villa. Martin Villa. Okay, you may proceed.
Your Honor, this morning, we are seeking the default judgment in the amount of $1,529.97, cost of court and post-judgment interest at the statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all documents and exhibits previously filed with the court without objection.
The court is taking judicial notice of all the documents in the court's file, specifically that an answer has not been filed and the required amount of time has passed. The court is granting the relief as requested by the plaintiff. And go ahead, your next case.
Number 12 on your docket sheet, Judge.
CL 185246-I Portfolio Recovery versus Javier Trejo. You may proceed.
Thank you, Judge. We are seeking a default judgment in the amount of $795.78, cost of court, post-judgment interest at statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court.
The court is granting the relief as, the court is taking judicial notice of all the documents in the court's file, specifically that an answer has not been filed and the required amount of time has passed. The court is granting the relief as requested on the record by the plaintiff. Go ahead.
13, Your Honor.
CL 185861-I Portfolio Recovery versus Carla, Karla Solitaire, Solitaire, Carla Solitaire. Go ahead.
Your Honor, this morning we are seeking a default in the amount of $3,201.08, cost of court, post-judgment interest at statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is granting the relief as requested on the record. The court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant and the required amount of time has passed. Okay, go ahead.
14, Your Honor.
CL 185864-I Cons Appliance versus Cynthia Montalvo. Go ahead.
Your Honor, this morning we are seeking a default amount of $1,798.74, cost of court and post-judgment interest at statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. And the court is granting the relief as requested on the record by the plaintiff. Okay, your next case.
Number 15, Your Honor.
CL 185977-I Portfolio Recovery versus Eunice Baca. Okay.
Your Honor, we are seeking a default in the amount of $3,579.88, cost of court, post-judgment interest at statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
The court is granting the court is taking judicial notice of the documents on the court's file, specifically that no answer has been filed by the defendant and the required amount of time has passed. The court is granting the relief as requested on the record by plaintiff. Okay, go ahead.
Number 17 on your docket, Judge.
CL 193622-I Portfolio Recovery versus Ana Rodriguez. Ana Rodriguez. Okay,
Your Honor, we are seeking damages in the amount of $2,969.21. This is a default cost of court and post-judgment interest at the statutory rate. At this time, I would move the court to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed, and the court is granting the relief as requested on the record by the plaintiff. Okay, go ahead.
Number 18, Judge.
CL 194225-I Portfolio Recovery Associates versus Jose Vega. Go ahead.
Your Honor, we are seeking a default amount of $2,834.28 cost of court and post-judgment interest at statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The court is granting the relief as requested on the record by plaintiff. Go ahead.
Number 19, Judge.
CL 194228-I Cascade Capital versus Yavet, YAVET, Cercas, CERCAS, Yavet Cercas. Go ahead.
Your Honor, this morning we are seeking a default amount of $5,220 cost of court and post-judgment interest at statutory rate. At this time, I would move the court to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed. The court is granting the relief as requested on the record by plaintiff. Okay, go ahead.
Number 20, Judge.
CL 194974-I TD Bank versus Jose Mendoza.
Your Honor, at this time, we are seeking a default in the amount of $2,975.96 cost of court post-judgment interest at the statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed. The relief as requested on the record by the plaintiff is hereby granted. Okay, go ahead.
Number 21, Your Honor.
CL 200872-I Portfolio Recovery versus Maria Escalante. Maria Escalante. Go ahead.
We are seeking a default amount of $1,574.43 cost of court post-judgment interest at statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
The court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed. The court is granting the relief as requested by the plaintiff on the record. Go ahead.
Number 23, Judge.
Okay, so number 22 is not yours?
I don't have it on my docket sheet. I have 23.
Okay, CL 20.
Yeah.
CL 21075-I Crown Asset Management versus Jose Sanchez. Jose Sanchez. Go ahead.
Thank you, Judge. We are seeking a default in the amount of $5,108.26 cost of court and post-judgment interest at statutory rate. I would move this court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed. The court is granting the relief as requested by the plaintiff on the record. Okay,
Next one is number 24, Judge.
CL 21-176-I Crown Asset Management versus Juan Sanchez. Juan Sanchez. Go ahead.
Judge, we are seeking a default in the amount of $10,888.68, cost of court and post-judgment interest at the statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed. The court is granting the relief as requested by the plaintiff on the record.
Next one is number 25, Your Honor.
Go ahead.
We are seeking a default amount of $4,898.14, cost of court and post-judgment interest at the statutory rate. At this time, I would move the court to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is this is on CL 20-1254-I Velocity Investments versus Olivia Palomares. The court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed. Therefore, the relief as requested by the plaintiff on the record is granted.
Number
Okay.
27, Your Honor.
I'm sorry, what number?
Number 27.
Okay, so 26 is not yours?
It's not on my docket sheet, Judge.
Okay, CL 21-0633-I TD Bank versus Edna Campos. Edna Campos. Go ahead.
Judge, we are seeking a default in the amount of $2,058.79, cost of court and post-judgment interest at statutory rate. At this time, I would move the court to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed. And therefore, the court is granting the relief as requested by the plaintiff. Okay, your next case?
Number 28, Judge.
CL 21-0736-I TD Bank versus Nancy Danae, Danaee Rosales. Nancy Rosales. Okay, go ahead.
Judge, we are seeking a default amount of $1,232.39, cost of court, post-judgment interest at statutory rate. At this time, I would move the court to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
The court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. Therefore, the relief as requested on the record by plaintiff is granted. Okay.
And the last case, Judge, is number 29.
CL 21-1244-I Cons Appliance versus Jennifer Bernal. Jennifer Bernal. Okay, go ahead.
Judge, we are seeking a default amount of $1,794.63, cost of court, post-judgment interest at the statutory rate. I would move the court at this time to take judicial notice of any and all documents previously filed with the court and admit any and all exhibits previously filed with the court without objection.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that no answer has been filed on behalf of the defendant. The required amount of time has passed. Therefore, the relief as requested by plaintiff on the record is granted.
Thank you, Judge. Thank you for letting me be excused, and that's all I have before the court this morning.
Okay, you're very welcome, sir. You have a good day.
Judge, have a great day. Take care.
Thank
If I
you.
may,
Oh, wait.
Mr.
Yes.
Velasquez, Court 5 did contact our court for you to contact them.
Okay, I will right now. Thank you. Okay,
No
thanks.
problem.
Bye-bye.
Okay. All right, Mr. Ramirez, what do you have?
Judge, good morning.
Good morning, sir.
Your Honor, I believe it's number 39 on your docket. I represent the defendant.
So you're here on the restraining order?
Yes, Judge. Mr. Juan Angel Guerra and I have conferred, and we do have, I have a request, and I tried to do a Rule 11 agreement, but he wanted me to put it on the record.
Okay, that's CL 22-0580-I. Toldos, TOLDOS LLC versus Stephen Miles Mendoza. Go ahead.
Your Honor, Dennis Ramirez on behalf of Mr. Mendoza. Judge, this is a TRO that was filed against my client. He is the property owner, and I know that there was some issues last week at the house. Law enforcement was called, and he was advised of the TRO. He had not been served yet. Mr. Guerra and I communicated last week, and I accepted service, received it on Friday. I'm still in the process of reviewing it. Mr. Guerra has also advised me he's in the process of getting me copies of the sheriff's sale deed and other pertinent documents. So we can get a week or a 2-week extension, Judge.
Okay, Mr. Guerra just logged on. Mr. Guerra, can you hear me?
Hi, ma'am. I'm just his assistant. He's not on. I always get on to make sure he's on. He's not on, right?
No, is he in another court?
He was, but let me call him, see if he finished already. Give me just 1 second.
Okay, let him know that we're called up his case.
Okay.
Okay, Mr. Ramirez, go ahead and continue. So you said that you all have been talking. All right, I'm gonna go ahead and I'll extend the restraining order for 2 weeks, and I'll have y'all come back on March the 21st at 11.
Thank you, Judge.
Okay. All right, I think that's him trying to log in again, so hold on.
I'll hold on before I log out, Judge. I got a little bit of time. I'm in between a federal debrief, so I've taken a break to come down and do this.
With no time, Mr. Ramirez?
I had federal court, and my apologies, Judge. It's raining in Houston, and the front's already hit here, and my jacket got soaked when I was walking over here, so I'm letting it air dry together with my tie.
Okay, Mr. Guerra, Mr. Ramirez made the announcement on the record that you all are conferring. So I'm going to give you an opportunity to exchange those documents. I've extended the restraining order to March the 21st, and I'll have y'all come back at 11 a.m. on March 21st. You're muted.
Did you say 24 or 21st?
21st, sir.
Okay, at the same time?
Yes, sir.
Okay, thank you so much, Judge.
Okay, thank you. All right,
Stay-
Mr. Ramirez, good luck to you at your federal hearing.
Okay,
Thank
stay
you, Your Honor.
safe, Judge.
Okay, thank you, Mr. Guerra. Stay safe. Okay, let me go back. Okay, number 22 on the court's docket, CL 201061-I, second round versus Gloria Saldivar. Go ahead and set that for the drop docket. See, number 26, CL 210613-I, portfolio recovery versus Kimberly Munguia. Go ahead and set that for the drop docket. And the rest of the cases were called. So we'll go ahead, and that concludes this morning's docket. We are now off the record. Let me stop